السلام عليكم ورحمة الله وبركاته. الحمد لله رب العالمين والصلاة والسلام على النبي الأمين وعلى آله وصحبه أجمعين. رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي آمين يا رب العالمين. Dear brothers and sisters, inshallah this is our last chapter on this module of Sharia aspects of business and finance. So here, inshallah, I'll be talking about on the documentation aspects of Islamic contracts or Islamic financial products and services. Where at first I'll talk about the basic nature of Islamic contracts, and then I'll talk about the different types and also the prohibited elements in Islamic contracts, and then I'll discuss on the Sharia aspects on documentation and also some of the conventional clauses which are used in whether they can be used in Islam in the context of Islamic financial products. So at first let us look at the nature of the contracts as we go through the fiqh muamalat, the very basic law of contract, where we can see in Islamic Sharia there are six pillars of a contract, where one is the first two is the expression, sirah, ijab, and qabul. There should be an offer and acceptance. Either it is pronounced verbally or it is understood or it is written. Number two, and then there should be price and commodity, the thaman and musman. So for the price, it should be fixed. The commodity, we should know the characteristic and it should be available, and there are some conditions more. And the third is the contracting parties, the offerer, al-mujib, and then the acceptor, al-qabil, the person who offers and the one who accepts. And there's all these six pillars, they also have conditions. Like in terms of the expression, the ijab and qabul, there are some conditions of the Sharia, like it should be past tense. It shouldn't be a future tense. If the future tense is used, it will turn into wa'ad or promise, but it will not be a contract. The scholars disagree on the present tense, but the present tense can be accepted by the majority of the scholars, but it cannot be a future tense. And then the confirmation between offer and acceptance. So the acceptance should be on the same product or the same price as offered in the offer. So it must the offer and acceptance must link, or they must agree on the price of the product or on the type of the product. The clarity of offer acceptance, both the offer and acceptance should be clear and understood by both of the parties. And the acceptance and offer, it is preferred that it should be at the same time, or it is connected in a way that uh, when uh, when the uh, when the offer is reached to the uh, person, to the other person, and he immediately accepts, means that there is no big time gap, or if there is a time gap but which is reasonably accepted if the parties are far from each other and they connect through letters or something else. But if there is an unreasonable gap in terms of the time, somebody offered 5 years ago, and after 5 years, if somebody accepts it, so that might not be accepted of course, provided the context or the custom. So these are the general conditions related to ijab and qabul. And in terms of the contracting parties, the offerer and also the acceptor, they also must be reach the age of puberty, means they are, or in Arabic is called al-baligh. They must be sane, that they are sound of mind, they are not insane, they are not crazy. Okay, and then they are matured, means they reach the age of majority, which is 18 years of age by the majority of the scholars, and also according to the law of most of the countries. So these are the general conditions for the parties in order for them to execute a contract. And in terms of the subject matter, the price and the commodity, the suitability of a subject matter for a contract. So a subject matter should be suitable. It's like it should be something halal, or it is something considered as mal or property in Sharia, which is something a permissible asset, or something that can be owned by people. Is and then state of a subject matter known to the parties. So the characteristics of the subject matter should be known. It is clearly known to the parties, and then the subject matter should be capable of handing over based on the custom. Like in case of real estate, means the buyer should be given the key, for example, or any kind of barrier should be removed to use the facility. Presence of a subject matter at the time of contract. Well, in some cases, maybe there are exceptions. So while um, like in case of our online transaction, but generally the subject matter should be present, or it should be at least available. The Prophet sallallahu alaihi wasallam said, "La tabi' ma laysa indak," that do not sell what you do not have. So the subject matter, what I am selling, it should be available. Even though it is not present, we can describe by characteristic. It should be at least available. Or we can also sell something which is not available, but we should have confirmation that we will going to have it if something under construction, for example. And the jurists, especially Imam Ibn Qayyim and contemporary jurists, they also allowed, if we are confirmed that we will have a certain kind of product, then we can also sell it. Um, so this is the general condition. Of course, there are detailed discussion in fiqh muamalat, but generally these are the conditions to a subject matter. And now, different types of Sharia contracts are there. So just to understand the nature of different contracts, I'll not go detail of those contracts, but just to give an overview of the nature of different types of contracts, and also what are the prohibited elements. Usually, the Sharia contracts we can divide into two types. Some are unilateral, some are bilateral. Unilateral contract is something, it doesn't need an acceptance, it doesn't need even a consideration or price from the other party. So, and in that case, the uncertainty is tolerable, and there is not much condition on that. And these are the contracts which are mostly gratuity, like gratuitous contract, like gifts or something. While bilateral contract is mostly the mutual exchange. There is should be offer and acceptance, and uncertainty in the subject matter is not accepted. And mostly these are contracts there is a mutual exchange, like sale or lease, etc. So this is the table to show the differences. So usually unilateral contract needs one party, bilateral needs two parties. Unilateral, there's no consideration is required, so it somebody can just give as a gift without any price. But for bilateral, there should be a consideration. For unilateral, acceptance is needed, but for bilateral, for unilateral, acceptance is not needed, but for bilateral, acceptance is required. For unilateral contract is mostly for gratuity, for gift, for donation, while bilateral is a commercial for mutual exchange. So the element of uncertainty, like garar, is prohibited in bilateral contract, while it is allowed or tolerated in the unilateral contract. The example of unilateral is tanazul, means waiving the right by a shareholder or by the wife to waiving the right to get nafaka, for example, donation and gift, hiba. The example of bilateral is like parts, loan contract, and albay, sale contract. And generally, if we look into the different types of contracts in Islamic finance, we can divide those in from different perspective. Some contracts are divided based on trust. Trust means here um, one of the condition of trust sale is that the seller has to reveal or disclose to the buyer his what is his buying price, so and how much, so that the buyer knows what is how much profit the seller is taking. So one of the example of trust sale is murabaha. Okay, but the opposite of murabaha is musawama, which is bargain sale, where the seller is not required to disclose his buying price. But sometime the contracts are divided based on the payment time of delivery or time of payment. So uh, the basic contract is that both of the price and the delivery of the commodity should be on the spot. But if the payment is deferred, then the contract is called by muajjal or by bithamanin ajil. But if the delivery is deferred, at that time the contract is called either by salam or istisna. And then in terms of usufruct, that there are contracts like ijara is a lease, or al ijara muntahiya bitamlik, lease ending with ownership. In terms of partnership, there are two famous partnership contracts. One is mudaraba and musharaka. So musharaka is a partnership on profit and loss. But mudaraba is a partnership on profit, but the loss is borne by the Rabbul Mal, or the provider of the capital. So in mudaraba, is actually one party provides capital and the other party works. And then if there is profit, they share. In terms, there are some contracts to do and act, like we have agency, or we call wakala, or we can also call juala, that if someone can do an act and he can achieve some level, okay, or something, then he will be rewarded. So that is the juala contract. While agency is a wakala, which is a representation and authorized to do and act on behalf of somebody else. And there are some contracts for safekeeping, okay, which is comes under the security contracts, like wadiyah, and there is a transfer of debt, which is called al hawala, and pledge, which is ar rahnu, which is a very good example of security contract. Is to keep something as a pledge in case the borrower cannot return, then the creditor can sell it off and get back. There is also guarantee contract like al kafala, which is mostly voluntary basis. So these are generally an overall of different types of bilateral contracts in the Sharia. While I'm not going to discuss all detail, just to give an overview of the nature of Islamic contracts. And then the Islamic contracts can be classified into in terms of the validity, whether they are sahih, batil, invalid, or fasid, imperfect. Sahih is a contract which is complete, valid. There is no issue in that. It is executed and it is complete. A contract is batil or invalid when one of the pillars of the contract is missing, when there is any violation in the contract. But imperfect is a contract where one of the conditions related to the one of the pillar of the contract is violated. So if that condition is fixed, if that issue is fixed, the contract will be valid. For example, if in one contract, if the if the price was not fixed. Then if the price is fixed, then the contract is validated. Or if in any contract there was riba, so if the element of riba is taken out, then the contract will be valid. So this is the example of al-fasid contract. And then there are some prohibited elements in Islamic contracts, which is the riba, interest or usury, maisir, which is gambling, and garar, which is uncertainty in the contract in terms of when we do not know the subject matter. And then a contract can be invalid when there is ikrah or force, means somebody is forced to do a contract, like somebody is forced to buy, and that force also has a condition that there is a threat to take his life or his organ. And then mistake is also one of the issue, that if somebody has done a contract by mistake. Well, the Hanafi scholars, they do not consider mistake in transactions, in financial transactions. However, it may be considered in other contracts. Inequality, which is gubon, means that if the product that we get, if it is significantly different from the characteristics that was mentioned by the seller, so then it is called al-gubon, or inequality, means the product is significantly different from the characteristics which was described by the seller. If there is a deception, means cheating in another way, in either way, in terms of the quality of the product, and also um, if if there is any kind of fraud in the contract, so this is that come under deception, that will lead the contract invalid. And then the contract of prohibited things like alcohol, wine, or any non-halal food made of pork, all of those are prohibited products. So these all of those will be forbidden. So now let us look at the Sharia principles for legal documentation. So first I'll talk about what is the Islamic perspective of documentation of products. Well, as we know, the Quran highly encourages documentation, because documentation is leads to transparency, and as we have learned, the maqasid sharia in finance is to create transparency, and then that's why gambling is prohibited. And in the longest verse of the Quran, in Surah Al-Baqarah, Allah Subhanahu wa Taala has Allah Subhanahu wa Taala ordered us to write down if we do any forward transactions. And in that case, if when writing, if somebody does not know how to read, so somebody should dictate. So that means actually that what we write, it should be clear and understandable to the contracting parties. So it's not only writing, the writing should be clear and clear understood by the both parties. And also the document should reflect the contract as intended by the contracting parties, which is very important. Islamic perspective of documentation is that the form should tell what is in the substance, so it should go together. So if the what is written in the document is something else, and what we do in the physical transaction is different, so it is not in accordance to the Sharia rules. And the legal documentation should also comply with the Sharia principles that are applicable to the respective contracts. As we have seen an overview of different contracts, we have Mudaraba, which is partnership, which we have trust sale like Murabaha. So all those contracts, they have conditions. So the legal documentation should consider all those conditions. If not, the contract will be invalid. In the case of conventional legal clauses, while in Malaysia, most of the lawyers, even in Islamic finance, they are from conventional background, and even in financial transactions, in terms of the legal documentation, mostly the conventional laws are followed. So the common clauses that do not violate Sharia principles, they are accepted. So common clauses in conventional legal documentation may be accepted with the condition that they do not contravene any Sharia principles. So, what are the specific prohibition in legal documentation? The first one, which is very important in Islamic financial products, are the prohibition of two contracts into one. The Prophet sallallahu alaihi wasallam has prohibited Naha Rasulullah sallallahu alaihi wasallam an bay'ataini fi bay'atin. The Prophet sallallahu alaihi wasallam has prohibited two contracts into one. Means that if we do legal documentation, we should keep into mind that especially in Islamic financial products where there are two or three contracts are combined in one financial product like musharaka mutanakisa, for example, or ijara muntahiya bitamlik. So there are two, three Sharia concept or two, three Sharia contracts are there. So we have to make sure that not two contract executed at the same time. It should be one after another, or even if we do one after another, there are also certain prohibitions. Like we cannot combine a sale contract with loan contract. So you cannot say like I loan you this with the condition that you buy my product. So this is prohibited because I am taking a kind of benefit because of I'm giving loan to you. So this is prohibited. However, some kind of contract like lease with partnership uh, might be accepted to be combined, but it should be in a separate contract, in separate ijab and qabul, offer and acceptance. It cannot be at once at the one offer. And then in terms of the execution of legal documents, two important elements are the sequence and the parties involved. The sequence is very important because we know that the Sharia principle is that we have to own something before we sell. So in case of murabaha, if I want to sell something based on murabaha, I must buy it, then I can sell it. So in legal documentation, we must take care of the sequence. If we do not follow the sequence, we just sell first and then we buy. So it is not reasonable. It's not accepted in the Sharia. And also the parties involved. Who are the parties when we are buying and selling? As we know that in the case of tawarruk, there are four parties. If I buy an asset and sell back to that person, it's called bayul ina. But if I buy an asset and sell to other party, then it is tawarruk. So there is a concern who are the parties, especially in Biolina and Tawaruk, in order to differentiate. And also, if I am buying or selling or doing any contract to other party, and that party maybe has any other interest, like he is one of the guarantor, so that can also trigger a Sharia issue. So we need to be concerned on the parties involved. And some these are the example of the conventional terms and conditions that is used in most of the legal documents. If we can see in some products, it usually is a long document and it will have usually this type of clauses. Like one of them is the right to recall. The right to recall in the conventional sense, it is as understood that if the customer has failed, especially uh, in a loan contract, if the borrower failed, the customer failed to pay for a few months, then his facility is terminated. Okay, so in the conventional sense, it is like the contract is invalid, the contract is terminated. But in the Islamic perspective, it is okay to certain aspect, but it is not okay from another perspective. Well, if, as we know, the Sharia allows putting condition, stipulation in a contract. So if a borrower cannot pay on time, so uh, the facility may be stopped. The seller can ask to make the payment. However, the Islamic Sharia does not give an automatic termination of the contract. The contract cannot be void, cannot be terminated because the borrower or the customer didn't pay on time or during the stipulated time. So this clause can be accepted in Sharia provided that it is just for the financial institution to terminate the facility and to ask the customer to make payment. The cross default is something where if a customer fails in one product, he defaults in paying in one product, then he is considered as defaulted in all the products offered by the bank. For example, if a customer he took home financing and car financing from a bank, and then if he fails to pay for the car financing, he is also considered as defaulted for the house financing as well. So that is called the cross default. So, it may make sense if it is from the same bank. The bank can consider is a default, but then again, the bank also have to needs to follow the conditions of that Sharia contracts, because the Sharia does not allow the termination of the contract automatically by the bank. The customer also has right. So we need to maybe redefine or we need to um, have to have relook at this concept of cross default and consolidation and set off, which is if a customer fail to pay to the bank, so the bank maybe can liquidate the customer's saving account or fixed deposit account. Well, it makes sense, as in the Sharia we also have the concept of muqassa, to set off. So if the customer fails to pay on a financing, fails to pay the home or car financing, the bank has the right to set off from the saving account, and it is also in line with the Sharia. Another clause is the prepayment clause that if a customer settles the loan earlier, he will get a discount that is called rebate. Well, in Islamic Sharia, while a rebate or we call ibra is allowed, if it is allowed if the seller or the creditor gives discount if to the borrower. However, it is not allowed if it is contractual. It is pre-promise. So when in the if when the legal document it mentions that if the customer pays early, settles early, he will be given discount. So it may lead to riba, as the scholars, majority of the scholars disallow it. While in the case of Malaysia, the Bank Negara as a third party, and in order to justice for the customers, it requires, it makes mandatory for the financial institutions to give discount or to give rebate, which is allowed based on the concept of maslaha. However, in a general sense, based on the majority of the scholars, prepayment clause is not allowed in the Sharia. Similarly, with the penalty or compensation clause, means if the customer fails to pay on time, then the financial institution is allowed to charge penalty, and sometimes it is compounded. While in the Sharia, it allows the financial institutions to um, uh, charge compensation, but it should be given to charity, or the financial institution can take charge some compensation based on the loss incurred to the financial institution. But other than that, if they charge penalty, it should be given to the charity. So that is the difference between the conventional clause of penalty or compensation clause with the Islamic. So that should be clarified or revised under the clause. principles. And then there are some issues in Islamic financing documentation that I need to highlight, and that many customers of Islamic financial institutions they go through and also they complain. One of them is the over formality of a document hinders a reader's comprehension and does not reflect clear communication. If we go to an Islamic financial institution, and when we look at we take any of their financing products, and when we need to sign, and then they will give us a very long document of 50 pages sometime or 20 pages with a very formal English, which is very difficult for us as for the public to understand. Now, so it is not in line with the principle of the Sharia that I have mentioned earlier. So it is recommended that financial institution they make the documents less formal, or is something which is easy to understand, or at least the officer in charge in the bank should explain. But it is also hard that many officers they are not um, they even do not understand the document, so they also reluctant to explain. They just ask their customers to sign the document, which is not in line with the Sharia principles. And there is a lack of expert practitioners with good knowledge and understanding of Sharia principles. So we need lawyers, Sharia lawyers specialized in Islamic finance, because especially the legal profession in the case of like Malaysia is mostly dominated by the non-Muslims, that most of the lawyers are non-Muslims. So it is difficult for them to understand the Islamic contracts. So we need more Sharia lawyers to who I also understand at the same time the contract laws to fill up this gap. And there is also issues with the Islamic products, as you know, the there are a lot of different types of contracts in Sharia, and all those contracts have different conditions. So the many lawyers they are not familiar with all those contracts and their natures. So we need to educate, and then we need to maybe standardize in this case the Islamic products, because another issue in product documentation is the differences of opinions among the scholars. So, however, from legal perspective, the law needs certainty in order to make it something void, something certain. If it is not certain, so the legal system will not be effective. So we need to minimize the differences, or at least in the case of Malaysia, where there is a National Sharia Advisory Council, so their opinion can be considered as the final if there is any dispute or any differences in terms of the product's validity or condition. So that is all on this chapter. So with that, I have already discussed the very nature of Islamic contracts, different types, and the prohibited elements, and what are the Islamic principles in contracts documentation, and as well as what are the current issues in Islamic product documentation. So with that, I thank you. Assalamu alaikum wa rahmatullahi wa barakatuh.